Gentlemen, I would assume that you all have followed my instructions and you have not discussed this case among yourselves. Am I correct? Yes, sir. Very good. These instructions just to kind of govern the way that you will conduct yourself during the presentation of this case. So if I could have your attention, I will go on and read these to you. You have now been sworn as the jury to try this case. By your verdict, you will decide the disputed issues of fact. The court will decide the questions of law that arise during the trial, and before you retire to deliberate at the close of the trial, the court will instruct you on the law that you are to follow and apply in reaching your verdict. You should give careful attention to the testimony and the evidence as it is received and presented for your consideration. But you should not form or express any opinion about this case until you have retired to the jury room to consider your verdict, after having heard all of the evidence, the instructions of law from me, and the closing arguments of the attorneys. During the trial, you must not discuss the case among yourselves or with anyone else, nor permit anyone to discuss it in your presence. You must avoid reading newspaper headlines and articles relating to the trial. My court personnel have strict instructions. You'll not be allowed to read newspapers. You'll not be allowed to listen to or watch television or radio because we don't want you all to hear anything that might ultimately influence your decision in this case. We want your decision to come from what you hear from this witness stand right here and from other evidence that you receive. Throughout this trial, you'll receive what we call written evidence, documentary evidence. You'll receive evidence from a projection of certain matters of evidence that will be presented as evidence in this case. And it will be received just like any other evidence. If something is allowed to be shown to you, I have approved it. Nothing will come to you that I have not approved. You will be allowed I have met with the attorneys in this case, you will be allowed to visit the scene of where this alleged incident occurred in the surrounding area. From time to time during the trial, I will be called on to make rulings on motions and objections. I talked to you a little bit about objections yesterday. And simply because one side objects, that doesn't mean that that attorney is trying to hide anything. It doesn't mean that that attorney is trying to keep something from you. It means that attorney is actually doing his job or her job. They are objecting to the admission of evidence, which they should do, and then I will rule on it. I will either sustain the objection or I will overrule it and permit you to see it or hear it. That's the way that will work. You should not infer from any such ruling that I make during this case that I have any opinions on the merits of this case favoring one side or the other. If I sustain an objection to a question asked of a witness and not permit it to be answered, you should not speculate what that answer might have been had I allowed it to be answered, nor draw any inference from that answer. During the trial, it may be necessary for me to confer with the lawyers outside the presence of the jury. It is impossible for me to predict when such a conference is going to occur and typically how long it will occur. You just should understand that we're going to conduct those conferences to consume as little of your time as possible. The attorneys for the parties will have an opportunity to make opening statements in this case, and that's going to be our next order of business when I finish here. We will have the opening statements from the attorneys. They will explain to you the issues in the case and summarize the facts that they intend to prove. The defense may wish to postpone their opening statement, which they're permitted to do under my rules, and make their opening statements at a later time. Or they may choose to go on with it now. That's their choice, but that is permitted under my rules. After all the evidence has been received, the attorneys will again have the opportunity to address you and to make their final arguments. The statements that the attorneys make and the arguments they make later are not to be considered by you as evidence, nor are they to be your instructions on the law. I will give you the instructions on the law. Nevertheless, the statements made by the attorneys are intended to help you properly understand the issues in this case, the evidence and the applicable law. So you should give them your close attention. The attorneys will not speak to you during the trial and will not thank you for your service at the conclusion. Their failure to do this does not indicate that they are being discourteous, but it does indicate that they are complying with the rules of court, which prohibits them from doing so. If you would like, and I'm going to permit you to take notes during the course of the trial, you're going to be furnished a notebook and pen for you to make notes. Now listen carefully to my instructions about notes. First of all, you're not required to take notes. You don't have to. But if you want to, that's certainly going to be permitted. Each of you should make your own decision about whether or not you want to take notes. If you do take notes, don't become so involved in your note-taking that you become distracted to the proceedings that are going on on this witness stand. Notes are only a memory aid, and a juror's notes may be used by that juror only to aid and refresh that particular juror's memory. They're not to be shared with other jurors, and whether you take notes or not, you must form and express your own opinion as to the facts of this case. So an individual's juror's notes may be used by that juror only and may not be shown or shared with or to other jurors. You will note that our court reporter over here, Miss Kathy Sanford, of course, was with you yesterday. She's our court reporter, and she's making a record of this trial. She has the responsibility of taking down everything that the lawyers say and everything that the witness say. She's, in my estimation, by far the most hard-working person seated in this courtroom. And from time to time, we're going to give her a break and let her refresh herself, and as well as give you a break in the mornings. My customary procedure is to take one break in the morning and to take another break at lunch and to take another break in the afternoon. And for those reasons, I want you to understand exactly what we're doing and why we're doing it. She's going to make a transcript of this trial, but when you begin your deliberations, those transcripts will not be available to you. In other words, what you will have to make your decision based on the evidence that's presented, the documents that are offered into evidence, and the testimony of the witnesses. You will have to do your best to recall. All right.